SCOTUS allows federal horse racing safety law to stay in effect pending litigation.
This is Dr. David Shine, and welcome to Business Law 101.
Parts of the story were reported in How on the Court. While I've not attended a horse racing event in years, there was a time I did attend them from time to time. I do not recall ever seeing a horse down or one of my winners flagged for being doped. Apparently, it is a serious problem. A report indicated that in 2019, for instance, more than 400 thoroughbreds died in the U.S. from injuries related to horse racing. And this is at a much higher rate than in Europe, accordingly. In 2020, Congress passed the bipartisan Horse Racing Integrity and Safety Act to improve safety in the horse racing industry. The hitch, if there is one, is that this new law was structured similar to the securities industry. The private nonprofit, the Horse Racing Integrity and Safety Authority, had the power to propose rules regarding doping, medication control, and racetrack safety. The authority's actions were still subject to review by the Federal Trade Commission. On the other side, the National Horsemen's Benevolent and Protective Association, a trade group of thoroughbred racehorse owners and trainers, went to federal court in 2021 to stop the law. The Fifth Circuit Court of Appeals ruled that the provisions of the law giving the authority the power to make rules were unconstitutional under a theory known as the private non-delegation doctrine. This is based on the concept that the government cannot delegate its powers to private entities. The authority then appealed to SCOTUS to request that its power to regulate stay in place pending the trial on the merits. It argued that more horses might die without the protection of this law. The Supreme Court recently ruled to allow the regulations to remain in place while the challenge works its way through the court system. This is Dr. David D. Shine for Business Law 101. If you've enjoyed this episode, please subscribe on your favorite platform.